Our first ELAN training of 2022, and I can see some new names on the list, so welcome everybody. For those of you who don't know, ELAN is the Employment Legal Advice Network, and we're funded by Trust for London. And the intention is to bring together the not-for-profit sector who are giving, which is giving legal advice in the employment rights area. And we've got various work streams that we're running, and one of them is training. And we've got various training events over the year, specifically aimed at improving knowledge and skills in the not-for-profit sector. We're really delighted to welcome Katie from Maternity Action here today, and she'll introduce Maternity Action shortly. It's really great when one of our members can bring the knowledge that they've got of their particular work to the table for everyone else to sort of learn from. So if anybody else wants to contribute at some point in the future, just let me know. But I'm not going to take up any more of the time of Katie. She's got about an hour, and there'll be plenty of opportunity to ask questions. If you want to ask questions throughout, if you could put them in the chat box just to keep the volume sort of manageable, and then there might be opportunity at the end also to ask questions verbally. I'll keep an eye on the chat box throughout, and if you've got any problems at all, just message me on there. I'll also put the details of how to join ELAN if you're not already a member, so you can take that away with you. But otherwise, thank you so much, Katie, for coming along this afternoon. It's great to see the sun shining, which is way better than last month. And now we're going to all learn something about statutory maternity pay. So thank you very much.
Lovely. Thank you, Victoria. So at Maternity Action, we advise primarily on maternity and parental rights and benefits, as we focus very much on pregnancy and maternity discrimination at work, rights during pregnancy, maternity leave and return to work, and family benefits, such as universal credit, Sure Start maternity grant, Healthy Start vouchers, the benefits you can claim when you've had a new baby. So this webinar is to focus very much on some of the detail behind statutory maternity pay. We're going to look at who is eligible, what the qualifying conditions are, some of the special issues and special cases that can come up around SMP, how to resolve disputes about SMP and what the appeal process is for getting SMP, the overlap between SMP and employment tribunal claims, and the overlap between SMP and other benefits. And as Victoria said, I'll have a few examples, so there'll be a chance to ask questions and hopefully a chance for questions at the end as well. Okay. Try and move the slides on. There we go. So statutory, oh, sorry, that was a bit of feedback from someone. Statutory maternity pay. Maternity pay and leave are actually health and safety rights. It's to ensure that you have some paid time off in the late stages of pregnancy and following childbirth. So it's different actually to other parental rights, which is, time off and pay to care for a child. Maternity leave and pay are very much health and safety rights. And so it's really critical to look at entitlement to statutory maternity pay as a starting point, because that's the only way, for the most part, that you're going to be able to have paid time off during maternity leave. Now, it's paid for 39 weeks, so that's broadly a 9-month period, normally by your employer or your agency, if you're an agency worker, or as we're going to look at, in some circumstances, it might end up being paid directly by HMRC. So the first 6 weeks is paid at 90% of average weekly earnings. And then the remaining 33 weeks are going to be paid at £156.66 per week. That's from 5th of April this year. Or 90% of your average weekly earnings if your average weekly earnings are lower than that flat rate of £156.66. So normally SMP should be paid by your employer in the normal way, so monthly or weekly through their normal payroll and at the normal time. Now, employers can pay it in a lump sum if they wish. If you don't want the employer to pay it in a lump sum, you can point out, well, actually, you might end up paying a little bit more national insurance contributions, the employer's national insurance contribution, by paying it in a lump sum. But really, that's the only argument that you can use. HMRC view it as being at the employer's discretion as to paying it in a lump sum if they choose to, and so there's not much you can do if they do decide to pay it in that way. So who is eligible for statutory maternity pay? Well, it's governed by the Social Security Contributions and Benefits Act 1992 from section 163 onwards. And so SMP, as well as statutory sick pay and other statutory parental payments, all have this distinction between an employed earner and a self-employed earner. And this is rather different from the test that we know of as employment advisors in terms of self-employed workers and employees. And so an employed earner for statutory pay purposes is someone who is gainfully employed with earnings by an employer who is liable to pay Class 1 national insurance contributions. So obviously, as we know, that can include a large number of those who we'd otherwise understand as being workers as well as employees. So 0 hours workers and employees, agency workers, those are sort of classed as bank nurses, supply teachers, some contractors, and some of those in the gig economy. If they work for an employer and they are paid through PAYE with tax and Class 1 national insurance deducted at source, they are likely to be they will fall within the definition of an employed earner. Their employer is liable to pay Class 1 national insurance contributions, or would do if their earnings were high enough, and therefore they are an employed earner. And if they're not an employed earner under the Contributions and Benefits Act, they are a self-employed earner, and that's somebody who is paying their own tax and Class 2 national insurance contributions through the self-assessment process. So in a way, it's a much simpler distinction. You don't need to ask things like, is there mutuality of obligation? Does your employer provide you with your equipment? This isn't actually relevant for statutory pay purposes. It might, of course, be relevant for other employment rights that we're going to be advising on, and what other employment tribunal claims they have. But if all they want to know is, can I get statutory maternity pay or statutory sick pay, then you need to look at how do they get paid, what sort of tax and national insurance do they pay. And if you've identified that they're paid through PAYE, they get any tax or national insurance deducted at source, or they would do if their earnings are high enough, then they are potentially eligible for statutory maternity pay from their employer. And so what are the qualifying conditions? Because obviously they've still got to meet certain qualifying conditions in order to be eligible. So there's 3 key things you need to look at. First of all, to get SMP, you need to have been employed by the same employer for at least 26 weeks by the 15th week before the expected week of childbirth. And I have got an example, so we will unpick this a little bit. You also still need to be employed in all or part of the 15th week before the expected week of childbirth. And you need to have average weekly earnings of at least the lower earnings limit. So that's currently £120 a week, going up to £123 a week from April this year. And you need those average weekly earnings of at least £123 a week in a very strict period, and it falls roughly within the middle of pregnancy, And so you find that 15th week before the expected week of childbirth, and you need to count back 8 weeks for somebody who's paid weekly, or 2 months for somebody who's paid monthly. And we'll look at an example as to how that works. But this very strict 2-month, 8-week or 2-month period is what is used to determine eligibility for SMP. So to find the 15th week before the expected week of childbirth, it's often called the qualifying week, as it's the all-important week for qualifying for SMP. You can do it manually. You can find the Sunday before the baby's due, or the due date if it's on a Sunday, and count back 15 weeks. And that will give you the start of the 15th week before the expected week of childbirth. Now, there is an online calculator on gov.uk. And so if you gather the information that you need, which we're going to talk through in this webinar, and you enter that into the calculator, that should give you an accurate indication. It depends a little bit on getting the right information to put into the calculator. So for that 15th week before the baby's due, you need to be employed in all or part of the week. Obviously, you don't have to work full time. If you only work for one day or part of a day in that week, that counts as being employed in that week. And the test, of course, is being employed. It's not actually physically being in work. And so if you were off sick or on annual leave or any other type of leave in which you remained employed, you have still met that qualifying condition. Agency workers we'll come on to in a moment. But the key test is employment in all or part of that 15th week before the expected week of childbirth. And average weekly earnings. So at least £120 per week at the moment. Actually, that's the year before's date, I've just realised. So obviously £123 from April of this year. So if you're paid weekly or full weekly, then you find that 15th week before the expected week of childbirth, and you use the average weekly earnings in that week and the previous 7 weeks. If it's somebody that's paid monthly, you find your 15th week before the expected week of childbirth, and you need to know what were the last 2 months' pay slips that your client received before the end of that 15th week, because those are going to be the 2 months' pay slips that you're going to use to work out average weekly earnings in those 2 months. And so you take the 2 months of earnings and divide by 2, times by 12, and divide by 52 to get your weekly earnings. Now you need to use the gross earnings that were actually received in that relevant 8-week or 2-month period. The only exception was introduced for pay. And I think we're probably getting to a stage where there's not going to be anybody that will any longer have furlough pay within that relevant period. But just in case you're advising anybody, perhaps who had their baby last year, that could be an issue. If they were on furlough pay, you can use what would have been their normal earnings in that period. But otherwise, the regulations are very strict. HMRC take a very black and white view of it. So you find that 8-week, 2-month period, you look at actual earnings received in that period, and you average them out to see if they are at least £123 a week. Now, if you were off sick in that period on statutory sick pay, only getting £96 a week, you're obviously going to fall below that average weekly earnings, and you won't be able to qualify for SMP. If there was a payroll error in that period, that can also impact on qualifying for statutory maternity pay. And as I say, employers can't use their discretion, and HMRC take a strict view. I think they think that it's essential for having certainty around eligibility for statutory maternity pay. So on the whole, you're not going to get anywhere by appealing to HMRC and saying these were unusually low earnings, and I've missed out and I shouldn't have done. They would say, that's it, strict criteria. If you didn't meet it, you can't get SMP. You can obviously look at claiming maternity allowance, but particularly for those who are on universal credit, that doesn't help. Because any maternity allowance is deducted from universal credit pound for pound. So women on maternity allowance and universal credit these days effectively lose their maternity pay. And so this is why it is so important to look at whether you are eligible for SMP. And, unfortunately, so many lose out on SMP because they were off sick on statutory sick pay during that period. Now, it can work to some people's advantage, because if you happen to have a bonus paid in that 8-week, 2-month period, or you happened to have some back pay or unusually high earnings, that's great. You're going to benefit from that in terms of working out your average weekly earnings for SMP purposes. Now, the other thing to point out is that having had your SMP calculated and started your maternity leave, supposing you then get a pay rise. So if that pay rise happens at any time between that calculation period, that 8-week, 2-month period, and at any time up to the end of your maternity leave, that means that your employer should actually recalculate your average weekly earnings as if your pay had been the higher amount that you're going to get for this pay rise, and they should pay you any extra SMP that you're owing. For some, it might mean that you become eligible for SMP, whereas before now your earnings were too low and you'd been claiming maternity allowance. And in those circumstances, your employer should pay you the additional amount that you are now entitled to over and above the maternity allowance. For a lot, for a lot of those, really, the pay rise is only going to make a difference to that first 6 weeks of statutory maternity pay, when you get 6 weeks of your average weekly earnings. And so if you've had a pay rise later on in your maternity leave, your employer should recalculate it, and you may get an additional amount for those first 6 weeks. So I was going to give you an example just to talk it through. And so in this one, HMRC do have this table of dates. I've given you the link there. I find it invaluable for advising on SMP. You may prefer to use the gov.uk calculator. But just to talk you through an example, if we have baby due 1st of February this year, so in the next couple of weeks, someone who started their job on the 1st of April 2021, so about 10 months ago, so your client comes to you and says, I only started my job 10 months ago. I work about 15 hours a week, but it varies. So my normal pay would be something around £150 a week. I get paid monthly on the 28th of every month. Can I get statutory maternity pay? So if you look at the very bottom row of the table of dates there, 1st of February, you can see falls within those first 2 dates. So the start and the end of the week the baby's due is the 30th of January to the 5th of February. So that's our expected week of childbirth. So we're looking at the bottom row on the table. And then if we move to that middle column, it tells us the start of that qualifying week. So 17th of October, 2021 until the 23rd of October, 2021. That is the 15th week before the baby's due. And so our client has told us that she gets paid on the 28th of every month. So that means that we need to look at the last 2 months' pay before the week of the 17th to the 23rd of October. So we're not going to be looking at October's pay. We're going to be looking at the previous 2 months. So we will need to know our clients pay in the 2 months of the 28th of August and the 28th of September, because those are the 2 months that fall before the end of the qualifying week, which ends on the 23rd of October. And it also tells us in that very bottom right corner, the latest start date in which she needed to have started her job. And that was the 1st of May, 2021. And she told us that she started her job on the 1st of April. So that's great, assuming that she did earn, her normal sort of £150 per week in August and September. She has qualified for statutory maternity pay. And so I've given you a checklist in this slide, really, just to help gather and to be aware of what are the questions you need to ask, what's the information you need to gather in order to be able to accurately advise on entitlement to SMP, or in order to be able to use the calculator to put in the information you need to get an accurate calculation. So you need the due date. And this will always be the date that's on the, it's a maternity certificate called the MAT-B1. And you get it from your midwife once you are at least 20 weeks pregnant. You can't get it earlier. And so SMP is always calculated based on the due date. And so if your client says, well, my baby was due on X date, but, baby came early, or my baby's due on this date, but I've been booked for cesarean 2 weeks earlier, doesn't matter the date the baby's going to be born. What matters is the due date on the MAT-B1 maternity certificate. And that's what SMP will be calculated on, and that won't change depending on the day the baby's actually born. It's all based on the due date, and that's in order to give some certainty. Otherwise, babies never arrive when they're expected to. And so otherwise we'd be continually having to revise it if it was going to be based around the date the baby was actually born. So you use the due date, you work out the expected week of childbirth, counting back 15 weeks. You need to find out when you started your job, how much you get paid, and whether you're paid weekly, fortweekly, or monthly. And if it's monthly, which day of the month do you normally get paid on? And that's the main checklist for the information that you need to advise on entitlement to SMP. So we're going to look at a few special cases, particular situations that tend to come up that you may well be asked to advise on. Premature births and stillbirths. So an employee is entitled to maternity leave and pay. Obviously, the pay will depend on if they meet the qualifying conditions after a stillbirth. And a stillbirth is defined as being after the end of the 24th week of pregnancy. Now, if the baby is born very prematurely or has been stillborn before that qualifying week, so before the 15th week, before the baby's due, then the relevant period for working out average weekly earnings will be the 8 weeks ending with the week in which the baby's born. So in that's one of the few situations in which you look at where the baby was born actually before the qualifying week. You use that week and the previous 8 weeks to work out average weekly earnings. And you can be treated as though you would have had your 26 weeks of continuous employment with your employer. If you would have been employed had your baby not been born very prematurely and you hadn't yet reached that 15th week before the expected week of childbirth. Now, agency workers, as I said at the very beginning, eligibility for SMP depends on you being an employed earner. And the employer for SMP purposes is whoever is liable for Class 1 national insurance contributions, which are being paid, deducted at source through through PAYE. And so for agency workers, that's normally the agency, because it's normally the agency that pays you through the payroll, deducts your tax and national insurance, and recoups the SMP from HMRC, because all employers and agencies are entitled to reimbursement of the SMP that they pay out. So there can often be an issue with agency workers. Obviously, it's much more insecure work, much more difficult for them to meet the qualifying criteria of having 26 weeks of continuous service by the 15th week before the baby is due. And so the SMP regulations, Regulation 11, specifically says that that continuous service, your 26 weeks of employment that you need, is not broken if the agency worker is unable to work because of pregnancy. So perhaps they took time off sick, or said they weren't able to work for pregnancy-related reasons, or where no work was made available by the agency. So as long as they are registered with the agency, they have a contract with them, but no work was made available, that shouldn't break their continuous service. And that would apply as well in that 15th week before the baby is due. If they weren't well enough to work because of pregnancy, or they were registered with the agency, but the agency didn't make any work available for them in that 15th week, they are still treated as employed, and they can still be eligible for statutory maternity pay. And I would say that the majority of disputes that I've raised with HMRC are around agency workers as well, because agencies, I think, are much less familiar with SMP requirements, and are much more likely to refuse SMP wrongly because there were gaps in that 26 weeks of employment. And so, HMRC, generally you can get a good result through HMRC by showing the contract, showing that they were available for work, but the gaps in work were beyond their control. No work was available, or they were taking booked annual leave, or they were off for pregnancy-related sickness reasons. So I was going to ask a question here. If anybody wants to either unmute, or I'll have a check on what's going on in the chat now, have a pause. But just wanted to throw this question out. Is statutory maternity pay payable if you're going to be dismissed, made redundant, or a fixed term contract's going to come to an end? So in other words, a situation where your contract's going to be ending, could be any of those scenarios. Your client comes to you, that's the situation, my employment's going to end, I'm pregnant. Can they still get SMP? Would anyone like to answer? Yes, looks like a couple of yes, depending on when the employment terminates, absolutely. Yes, as long as they meet the qualifying conditions, absolutely. I think you all know this already. Wonderful. So, and now it won't let me move on. Oh, here we go. So yes, the answer is it all depends. And so, I mean, the main rule is, as one of you put in the chat, if you've qualified for SMP, for the most part, you are then eligible for it for the full 39 weeks. And so if you've reached the 15th week before the expected week of childbirth, and you've met the other qualifying conditions, of course, that means nothing that happens after that week is going to have any impact on your SMP. So if you've reached the 15th week before the expected week of childbirth, you've met the other qualifying conditions. If you are subsequently dismissed or made redundant or your fixed term contract comes to an end, that won't make any difference on your eligibility for SMP, and you're still entitled to be paid it for the full 39-week period. And so the employer must still continue to pay the SMP if they're in business. As I say, in those situations, they can pay it in a lump sum if they want to, or they can carry on continuing to pay it through their payroll, even if your contract with them has ended. Or if they've gone into liquidation, then that's a situation when HMRC will step in and pay any SMP that's owing. And so if, however, if your job has ended before the 15th week, before the expected week of childbirth, or you're not eligible for SMP for other reasons, maybe your earnings weren't high enough, then obviously you for the most part, you can't qualify, although I will come on to one situation where you might still be able to claim SMP, and you're going to have to claim maternity allowance. So it depends on when your contract ends, and for the most part, if it's before the 15th week, you'll need to claim maternity allowance instead. And the other thing that we get quite a lot of questions on is somebody who has been working in the UK under a visa, they've qualified for SMP, and then their visa has expired, or they've left the UK. Should the employer still be paying their SMP? And yes, absolutely. Once you've qualified for it, if your visa subsequently expires or you leave the UK, it makes no difference. The fact is, you are entitled to it for a full 39-week period. Now, there's certain situations where that will bring your SMP period to an end, which we'll come on to. But you know, the starting point is that SMP is payable for 9 months, and once you've qualified for it, you're entitled to get it for that 9-month period. And so, what is the SMP period? Well, it starts, the earliest it can start is 11 weeks before the expected week of childbirth. Obviously, it is up to you to choose when you want to start your maternity leave and pay, and you need to give the correct notice to your employer to state that date. But the earliest you can start it is 11 weeks before. Now, obviously, if you give birth much earlier, then SMP will automatically start the day after childbirth. And the very latest that you can choose to work is up until the date that your baby is born. And if you were working on that day, that automatically triggers the start of your maternity leave and pay from the day after you've given birth. And the only circumstance in which an employer can trigger the start of the SMP period is in the 4-week period before the expected week of childbirth. And if you're absent because of pregnancy, so that could be pregnancy-related illness or maternity suspension on health and safety grounds, then in those circumstances, your employer can automatically start your SMP from the day after your first day of absence. But that's only in that 4-week period, no earlier. Obviously, you can work for up to 10 days during your SMP period without losing any SMP. And the only situation in which SMP might end before that, the end of the 39-week period, is obviously if you go back to work earlier, or if you start working for a new employer, and we'll come on and look at what we mean by a new employer. And in that situation, you must tell your existing employer to stop paying your SMP. And this brings us nicely on to that complicated situation, which we get asked a lot about on our advice line, is for those who have more than one job, which is, you know, so common these days, and those who are changing jobs during pregnancy or maternity leave. And so if you have 2 jobs, can you get SMP for more than one job? Well, yes, if you meet the qualifying conditions in each job. And so you need to look individually at the qualifying conditions in each job, and each of those employers would pay you your SMP. And your rights in each job are completely separate. So your SMP period can start and finish at different times in each job. and the fact that you may still be on maternity leave and pay with one employer doesn't prevent you from going back to work earlier with your other employer. But that's only in a situation where you have two jobs in which you qualify for SMP in both jobs. Now, if you're going to change jobs after the 15th week before your expected week of childbirth, so you've qualified for statutory maternity pay from one employer, but your contract's ended, or you've decided not to go back to work for that employer, and you've been offered a job with a new employer, the rule is this: it depends on whether you were employed by that employer in the 15th week before your baby was due. Because if you were, you didn't get SMP from that particular employer, but they employed you in the 15th week before your baby was due, you can work for them both before and after the birth without it affecting your SMP. If you weren't employed by this new employer in the 15th week before the expected week of childbirth, but you do any work for them after the birth, then you need to tell the employer that's paying you SMP to stop paying the SMP. But that's only if you do any work for this new employer after the birth. You can, in fact, work for a new employer before the birth without it affecting your SMP. So that's the definition of a new employer, is somebody that didn't employ you in the 15th week before your expected week of childbirth. So now I've bamboozled everybody with more than one employer and changing jobs. We'll move on to how to resolve disputes about SMP. So I think the starting point is always to say to the employer or the agency, do you know that you're going to be reimbursed for most of the SMP that you pay out? We shouldn't assume that all employers and agencies, particularly some of the very small agencies, don't assume that they know that they can get this money back. So they get 92% back, that's all employers. Smaller employers and agencies claim 103%, so they get a little bit more than the full amount they pay out. They can get advice on paying and reclaiming SMP from the HMRC Employers Helpline. And if they're unable to pay the SMP, if they've got cash flow problems, or they're really micro business and they need the money up front, they can request advance funding. And so that's, I've given you the links there to the HMRC website for employers. And I think those, pointing out some of those things can be really helpful to trying to prompt the employer to, get help to work it out correctly, for instance, and to be aware that they can claim the money back if they need it. And I always say to clients, if we've got to the stage where they're going to have to contact the HMRC Statutory Payments Disputes team in order to ask for a formal decision, tell your employer you're going to contact HMRC for a disputes team, and HMRC will be getting in contact with them. I think it's amazing what a rocket it puts under a lot of employers. And I often think that they're far more worried about HMRC contacting them often than they are about having a potential employment tribunal claim brought against them. So you'll be amazed at how it can speed things up. But if the employer is refusing to pay SMP, or if they're paying the wrong amount, or they've gone into liquidation, or there's any dispute or failure to pay SMP, then you need to go to the Statutory Payments Disputes team. I've given their telephone number there. They're extraordinarily busy. They are hard to get through to. You can also write to them. Their address is on their website too. There is a time limit. The regulations say that it's 6 months from the start of the SMP or the statutory pay period that's under dispute. However, there is discretion, and so don't let that put you off. And I would say, regardless of how long ago that was, if SMP or statutory payment hasn't been paid, I would go to the disputes team and ask for a formal decision on whether your client was entitled. Now, obviously, you need to consider protecting your client's position while you're waiting for HMRC's decision. If there's any likelihood that HMRC are going to find they're not entitled to SMP, clearly they want to put in a claim for maternity allowance in the meantime. Not only will that give them some money during their maternity leave, but it also means maternity allowance claims can only be backdated for 3 months. And so you don't want to leave it too late, because if it takes HMRC 4 months to make a decision and they say, no, you weren't entitled to SMP, then if the client puts in their maternity allowance claim, it's only going to be backdated for 3 months. So they're going to lose some of their maternity allowance. If your client's been claiming maternity allowance while they're waiting for the HMRC decision, and they then get their SMP awarded, then what you can do is that the employer can just pay the balance, the difference that they are now entitled to. So it can be sorted out in that way. Now, you can also make you can also ask HMRC disputes team for a formal decision on entitlement to statutory sick pay, statutory maternity pay, and other statutory parental payments, if you think that you've been dismissed solely or mainly for the purpose of avoiding liability for statutory pay. And so this could be one of the few situations in which somebody's lost their job, maybe just before the 15th week before the baby's due, and you think, this looks suspiciously like the employer pushed them out in order to try and avoid paying SMP. Obviously, you may well also be considering things like unfair dismissal, automatic unfair dismissal claim, or pregnancy discrimination claim. But I would suggest also going to HMRC and asking for a formal decision on entitlement to SMP, because they were dismissed for the purpose of avoiding liability for statutory pay. And so HMRC will, you obviously need to set out all the circumstances and ask HMRC to come to a decision. And if HMRC decide, yes, that they agree, they think you were dismissed to avoid paying SMP, they will look at your client's average weekly earnings in the last 8 weeks before the dismissal. So the fact that they weren't employed up to the 15th week before the expected week of childbirth, it won't matter. You look at the last 8 weeks of employment for working out average weekly earnings. And if HMRC decide that you are entitled to SMP, either in a dismissal case or where there was a dispute about eligibility for SMP, they will order the employer to pay it. And if the employer then fails to pay it, HMRC step in and pay it directly. And if the employer's gone into liquidation, HMRC steps in and pays SMP directly. And this is why it's so important to use this, this dispute process, because it can help clients to get their SMP much more quickly and in many circumstances directly from HMRC if the employer is just refusing to pay. And so the appeal process, this applies to all statutory payments, is, as I say, you start with your phone call to the disputes team. And once you get through, you say, I want a formal decision. My employer's refused SMP. I've been issued often with an SMP1 form. I don't agree with it. Or I think, they're just not getting back to me. And I don't think they're going to pay me my SMP. And HMRC will normally send out forms to the employer and to your client to gather the key information. Why they don't put a form or something online that could all be filled out and sent through to them, I don't know. It would certainly speed up the process. But they actually, this part of it is a fairly informal decision-making process. And what they like to do is they like to pick up the phone and speak to the employer. They look at the evidence, they pick up the phone to the employer and they say, I think your employee has qualified for SMP, you need to pay it. And it works. There's delays, but it works. And if they do award SMP, they will write to the employer and to your client and say, yes, we've decided you are eligible. And they will order the employer to pay the SMP, usually by the next payroll. And if they failed to pay, then you can ask HMRC to pay it directly. Now, if HMRC turn down SMP and they make their formal decision and say that they're not awarding it, obviously you can appeal if you think HMRC have got it wrong. And certainly in the pandemic, I did a number of these appeals for agency workers in particular, where I didn't feel that HMRC were applying that Regulation 11. They were looking at, was the agency worker actually working for each of the 26 weeks up to the 15th week? And in many situations, the agencies couldn't offer any work. Their workplaces were closed during lockdowns and things like that. And so we overturned a number of decisions. So we wrote back to HMRC disputes team to say, I want to appeal. In the case of some of my agency workers, for instance, I think they had met the qualifying conditions. This is what the Regulation 11 says, and it's actually a fairly informal process still. And what I found is HMRC will tend to review it, quite a number of times. So just keep writing back to them if you don't agree with what they're saying. And if ultimately they still refuse and you want to appeal, then that appeal would be to the first tier tax tribunal. Now, there's very, very few decisions on SMP by the tax tribunals. So normally it gets resolved through this process. And so what's the overlap between SMP and employment tribunal claims? Well, obviously, SMP, occupational maternity pay, and other statutory payments are considered to be wages for the purpose of an unauthorised deduction of wages claim under the Employment Rights Act, Section 13. So you can claim it, obviously, in an employment tribunal claim. And sometimes employment tribunals will award that additional 6 weeks at 90% of average earnings if, for instance, your client has claimed maternity allowance and they've separately brought claims perhaps for dismissal or pregnancy discrimination. And they, had they not been dismissed or discriminated against, they'd have qualified for SMP, they'd have got that additional 6 weeks at the higher rate. And so, often part of your schedule of loss, you can get that additional 6 weeks of pay through your employment tribunal claim. But for the most part, I wouldn't claim loss of SMP through an unauthorised deduction of wages claim. I would use this formal dispute process through HMRC. You are much more likely to get your client the SMP that they need actually during their maternity leave, rather than waiting another 12 to 18 months for their employment tribunal claim to be decided. And for the most part, employment tribunals will want HMRC to have made the decision on entitlement to SMP and how much SMP was payable as well. But obviously, while going through the statutory payments disputes teams, you may want to consider other employment tribunal claims for unfair dismissal, automatic unfair dismissal, or pregnancy discrimination. And nearly at the last slide, I was just going to flag some of the overlap with SMP and other benefits. So for universal credit, SMP is treated as earned income. And so it's largely disregarded under the work allowance and the earnings disregard Now, if your client has had a lump sum payment of SMP, and for the purposes of a universal credit claim, that SMP will just get paid in 1 month, and it will only be treated as earnings in that month, as far as universal credit is concerned. That means, quite likely, your client won't get any universal credit in that month. But for the remaining 8 months of what would have been the SMP period, there will be no reported earnings anymore. And so your client will be treated as having 0 earnings in those remaining months. That could be beneficial to them. They could become eligible for they could become eligible for universal credit. It's going to depend on other factors like their partner's earnings. But being treated as not having any SMP for the remainder of that period could mean they get more universal credit after the lump sum payment, and that could also entitle them to things like the Sure Start maternity grant or Healthy Start vouchers. Now, if you have a client who's on child or working tax credit, then £100 per week of SMP is disregarded. So that's £3,900 over that 9-month SMP period. And you are treated as working for working tax credit purposes during that SMP period. So there's no reason why you should lose eligibility for child or working tax credit while you're on SMP. Now, sadly, as I've mentioned a couple of times, if you're on maternity allowance, it's treated as unearned income and it's deducted pound for pound from universal credit. And so this is disastrous. Maternity allowance used to be regarded as a safety net. It was such a valuable safety net for anyone that missed out on SMP, perhaps because they were on statutory sick pay during pregnancy and couldn't qualify, for instance. You always used to be able to say, it's okay, you can claim maternity allowance. But then, of course, you have to ask, are you claiming universal credit? Because if they are, then very often you obviously need to work out whether they're going to be better off claiming the universal credit, or are they going to be better off claiming maternity allowance? Is it going to give them any extra on top of what they're already getting with universal credit, or is it actually not going to be worth their while? Because sadly, for all too many now, they effectively lose the benefit of their maternity pay if they're on universal credit. And as you know, Child Poverty Action Group brought a judicial review, but it wasn't successful. So that's the situation we're in. But that's why SMP is so important, and it is so important to really check every avenue to make sure if your client could have qualified, that they can get that SMP instead of the maternity allowance. And I'm going to just touch very briefly on occupational maternity pay. Obviously, for the most part, occupational maternity pay will top up the SMP or the maternity allowance that you're getting. And so the contract will specify what the employer is offering. It may be a period of full pay or half pay, or whatever they offer under the contract. Entitlement to occupational maternity pay will often be linked to the qualifying conditions for SMP, but not always. So you need to check the policy and see what the employer's conditions are. And as many of you will know, many maternity policies will have some sort of return to work provisions as well, where the employer will say, if you don't return to work for 3 months or 6 months, or often quite a lot more onerous conditions, I think we're seeing at the moment, they'll say that you need to return the occupational maternity pay. Now, obviously, that's only ever the part that is over and above the SMP. So the SMP part is never repayable. And that any repayment conditions need to have been clearly stated in the policy, or they need to have been agreed with your client in advance of the start of maternity leave, if the employer is to be able to rely on that in claiming back the occupational maternity pay. There's sometimes a question about if you've returned to work after your maternity leave, but you were on sick leave or annual leave, is that still going to count towards your return to work period? Now, with, obviously, as with any contractual benefits, you need to check the policy and see what it says. If it doesn't say anything, I would say that for the most part, you're still employed during sick leave or annual leave. And if you've been back at work, but you've been using up other types of leave, that should count towards your return to work. But you need to check the policy, obviously. Now, if somebody is not able to return to work after maternity leave, and the employer is saying, well, your occupational maternity pay is now repayable, they will often deduct the amount that's repayable, perhaps from any accrued and outstanding annual leave that the employee is entitled to when they're resigning from their job. Now, if the employer does that, and there's a dispute over whether that occupational maternity pay is repayable, it wasn't agreed, or there's dispute over the amount of occupational maternity pay that's payable, and the employer just goes ahead and deducts it from outstanding annual leave, then I think there may well be a claim for unauthorized deduction of wages. And that can be a way to resolve disputes around how much occupational maternity pay was repayable. So some other resources, I think I've given this link to the HMRC Statutory Disputes Team's pages. The DWP guidance on SMP and maternity allowance, it's their technical guidance. That's very good, has a nice clear description, for instance, on continuous employment for agency workers. It's also pretty good for the issue around those who have more than one job or changing jobs as well. And obviously Maternity Action's website, we have information sheets on all of these issues that we've covered. So premature births, stillbirths, maternity pay for agency workers, and all of those broken down into lots of FAQs. So those are advice line numbers. We also have an email contact form if either you or any of your clients want to contact us for help on a maternity pay question. And as I say, use that checklist on slide 8 for gathering the information that we need to help you with a maternity pay question, and do please contact us through that. And happy to take any questions.
Thank you so much, Katie. There's one question in the chat box already from Michelle. So she asks, what if your statutory maternity pay date was set and you went on leave? I think that means and the baby came early. I think you may have dealt with that actually, but anyway.
Yeah, so no, that's fine, Michelle, and it does cause a lot of confusion. For the most part, if you've started your maternity leave, the likelihood is your SMP's already started being paid. And so although you may have hoped you were starting your maternity leave 6 weeks before your baby was going to come, baby comes early, it won't make any difference. Your SMP or maternity leave has already started. Nothing's going to change. Doesn't mean your employer has to recalculate the dates. As I say, in this scenario, you're probably already on your maternity leave and your SMP. It's just you didn't get the benefit of that time at home to psych yourself up.
Thanks. Anyone else got any other questions while we've got Katie? Nothing else in the chat. You can put your hand up or unmute if easier. You've covered everything, Katie, clearly. Oh, okay, we can see now. No more questions? Okay. Well, in that case, thank you. Oh, yeah, thank you, Emily, in chat. Thank you so much, Katie. That was absolutely fantastic, really helpful. As I've said in the chat, I will share the recording with you all. I'm sure Katie wouldn't mind me saying that if there's anything that crops up afterwards that you think, oh, actually, I really wish I'd asked that particular question, you just send it to me, or and I'll make sure that Katie has it at some point. So that was really fantastic, really clear, and a really useful recording, I think, to keep referring back to keep reminding ourselves of the rules. So there's a meeting on Friday for ELAN, 2 o'clock. Hopefully you'll be there. It'd be great to see you. And we've got some more things coming up over the next few months, so keep an eye out on the emails that I send around. I will send an email asking for feedback, because we've been asked by Trust for London to try and keep some feedback, even if it is simply, that was fantastic, thank you very much. And I will take most of the comments on here and use that as feedback. But if there's anything constructive, timing wise, if I actually think 9 in the morning is better or something like that, let me know, because obviously this is all meant to be for you. So the more it suits you, the better it is for us. But I think we can kind of all, thank you very much, Katie, massive round of applause from us, and thank you so much for giving up your time. It was really great.
Thank you, nice to see you all.